Welcome to Frank Bruno Law. I received a question, and it's about guardianship, and I'm going to answer it. But first, if you have a question for me, please go to Frank Bruno Law. You could set an appointment. I'll give you a free telephone call. We'll speak about your situation. So the question about guardianship was, how many types of guardianship are there? So I'll give you a brief little informational piece about guardianship. There's guardianship of children in the family court, and that's for children up to the age of 21. It's a weird little dynamic in the family court. Custody only lasts until a child is 18. A person is considered an adult at 18, but there is guardianship in family court, and that can extend until the child is 21. That's not the type I'm talking about. But if you asked about guardianship, I at least figure I'll mention it. There's a guardianship, a 17A guardian, in surrogates court. That's a different flavor of guardianship, and I'm going to push that one to the side as well. The three types of, so I'll tell you about guardianship in Supreme Court for an incapacitated person, and there's three types. A guardian can be a guardian of the person, a guardian of the property, or guardian of the person and property. Guardian of the person handles the person's affairs of health and personal well-being and living space and how to arrange for bills to be paid. That's a guardian of a person. Guardian of the property means the person's assets and income. It could include real property, but otherwise just their financial well-being. And then a plenary guardian, or there can be one person that's the guardian of both person and property. And this if a person really has significant incapacity and they need assistance with all areas of their life. There are 4 types of guardianship across 3 different courthouses in New York. We have guardianship in the family court. That's where one person seeks to be the guardian, like the physical caretaker, a parental role for a child. No money is involved. Then there's the type of guardianship in surrogates court. There's actually 2 of those. An Article 17 guardian and an Article 17A guardian. And the 17 is similar to the guardianship in family court, except it has the additional priority, obligation, the additional power of a guardian being able to handle money. And that's why you would file in the surrogates court, to get the jurisdiction over the money. If a child inherited money or was the recipient of a personal injury or a lawsuit, monetary amount, you might use that Article 17. Article 17A in the surrogates court is for a parent of an adult developmentally disabled child. So that's for an adult guardianship, typically parent to child, and mental or physical disability. And then finally, the 4th type of guardianship is Article 81. It's in the Supreme Court, and it also is commonly used for one person filing to be the guardian of an adult. The statute doesn't say it has to be an adult, and there are some cases where it was interpreted that it was a child, but overwhelmingly, commonly it's used for an adult. So different types of scenarios, but a person gets the adult onset of dementia or Alzheimer's, or a stroke, or some other physical ailment. It doesn't have to be that fact pattern, but that is a typical way that it presents. So those are the 4 types of guardianship across 3 courthouses: family court, surrogates court, and Supreme Court. If you need assistance with any of those areas of guardianship, I handle it, my office handles it. FrankBrunoLaw.com. FrankBrunoLaw.com.